Hi, my name is Graham Cushion. I'm one of the partners at Poppleston Allen, and I deal with licensing and also regulatory crime. And I'm going to talk to you today about reviews of premises licenses. So what's a premises license review? Well, when the Licensing Act came out in 2003, well, it actually was enacted in 2005, it created a much more libertarian scheme of licensing, with the potential, for example, for 24-hour alcohol sales. Not that too many places have that, but with it came a greater degree of accountability, and the primary and fundamental enforcement tool available to the police and other authorities is the power of review of a premises license. So when the Licensing Act came into being, there was actually only one type of review available to the police and other authorities. So for these purposes, we'll call this the normal review process. And that would be utilised by the police, for example, if there were recurring problems of crime and disorder associated with the premises, or perhaps there was intelligence, or better still evidence, of a problem with underage people frequenting the premises and being served alcohol. Then the police would use that review process to bring the premises licence holder together with its licence back before the licensing committee, with the licensing committee being asked to take action on that licence to remedy the problems that were being reported. Within that process, the licensing committee would have a number of possibilities open to them in terms of remedial action. They could remove the designated premises supervisor if it was felt that the direct premises management was at fault. They could modify the conditions on the licence. They could reduce the hours on the licence, or remove a licensable activity like music, or in theory the sale of alcohol. Or in the worst case scenarios, they could suspend the licence for a period of up to 3 months, or indeed revoke the licence completely, which would mean that the pub, for example, would no longer have a licence whatsoever. So that's the sort of standard review process. The second type of review came in, I think, in 2007 as a result of the Violent Crime Reduction Act, and that was meant to be a more powerful form of review, reserved really for serious situations. It was envisaged that it would be used for situations where there was a shooting or a stabbing, particularly if it was a gang related and there was a fear of repercussions, so there might be another serious incident if the premises were allowed to continue to trade. The expedited or summary review process, as it's known, involves bringing the premises licence holder and its licence before the licensing committee very quickly indeed, within 48 hours. And at that point, the police would normally be asking for suspension of the licence pending full review. It's important to realise that on this nastier form of review, it's only the police that can exercise it, not any of the other authorities. Normal reviews can be instigated by an environmental health officer or by local residents, but an expedited review can only be instigated by the police and requires sign-off from a superintendent or above to say that the premises are associated with serious crime, serious disorder, or both. Your premises licence is normally being reviewed because there are problems associated with the premises which you perhaps haven't been the best at dealing with. Those could be noise problems causing residents or environmental health to review your licence, or repeated instances of crime and disorder leading the police to instigate a review of your premises licence. You don't normally get reviewed without any previous warning. It's normally a staged process, and whoever's bringing the review normally wants to be able to say to the licensing committee, I gave the premises licence holder an opportunity to put their house in order, but they didn't take it. And as a result of that, I felt I had no option but to bring the matter to the licensing committee for them to make a decision on the future of the licence. So any responsible authority or interested party, and by interested party I mean normally a local resident, although it could be another business owner in the area, can apply for a normal review of a premises licence. In the case of an expedited review, it can only be the police. There is a right of appeal against a review of whichever type. So essentially the committee make their decision on the review, and that decision takes effect 21 days after the decision is made. That is to allow for a 21-day period in which any party may appeal the decision that they've made. and the decision on the review, if there's no appeal, will come into play after 21 days. If somebody does appeal, then the decision won't come into play until that appeal is determined. So interim steps are what the licensing committee impose on the first hearing in the expedited review process. So normally they will be asked by the police to consider a suspension of the premises licence, to stop the business trading pending a full review of the licence, which will take place within 28 days. So essentially keeping the business closed. So if the incident in question was, for example, gang related, then that should quell any fears over repercussions, because the premises won't be open for any further incidents to occur. So that's it on reviews. Thank you for listening. If you do have any further questions relating to reviews process or a current application that you're facing, feel free to contact me. My email address is g.cushion@popal.co.uk and my mobile telephone number is 07769 720 319.